A sponsor called me a while back, pretty pleased with himself. He said, we're closed. Investor signed the subscription agreement, wired the 100,000. He's in, and I had to slow him down because a signed form and a wire don't mean what most sponsors think they mean. This is Syndication Attorney Field Notes. I'm Tilden Moschetti, a syndication attorney, and today's field note is about the subscription agreement in a Regulation D private placement. The question sponsors ask me is simple. What does this document actually do? And the answer trips people up because the moment the deal really closes is not the moment they think. So let me give you the direct answer first. The subscription agreement is the point of sale in a private placement. It is the contract where your investor formally offers their capital, makes binding promises about who they are, acknowledges the deal documents, and where you, the sponsor, decide whether to accept them into the deal. It is not an intake form. It is not a receipt. It is the moment the investment is closed. Now, here's why sponsors get this wrong. Modern raises run through portals. The investor scrolls, checks a few boxes, clicks through, and it's done in a couple of minutes. That feels great for marketing. Smooth onboarding, low friction, but that smoothness can make the document feel like a formality instead of a contract. And the substance is what matters later. Inside that agreement, the investor is making what we call representations and warranties. Those are statements the investor swears are true. They swear they read and understood the PPM. They swear they can absorb a total loss of the investment. They swear they're buying to invest, not to flip. Those promises are your shield if a deal goes sideways later. So a generic template that captures a signature but not the right representations gives you a lot less protection than you think. The signature is the easy part. The substance is the point. Now let me put the document in its place because it never works alone. Think of three documents. The PPM, the private placement memorandum discloses the deal. It tells the story and the risks. The investor doesn't sign it. It's more like a very detailed warning label. The operating agreement governs the entity. It's the rule book, voting, distributions, transfer restrictions, and the subscription agreement closes the deal. It's the only one of the three the investor actually signs to invest. And it does something clever. Instead of chasing 40 limited partners for signatures on a 60-page operating agreement, the subscription agreement includes language where the investor agrees to be bound by that operating agreement. One signature ties them to the whole governance structure. So the simple way to hold it, the PPM discloses, the operating agreement governs, and the subscription agreement closes. Okay, now let's go back to my sponsor who thought he was done. Investor signs for $100,000 into a commercial real estate fund, wires the money. Here's the thing, that signature is an offer, not a done deal. It's like submitting an offer on a house with earnest money. You don't own the house, the seller still has to accept. So in a syndication, that money usually sits in a holding account while the sponsor reviews the investor's answers. The investor's signature is an offer. The sponsor's countersignature is the acceptance, and that matters because a well-drafted subscription agreement gives you, the sponsor, the right to reject a subscription. Maybe a background check turns up something. Maybe the investor turns out to be a poor fit for the group. Maybe accepting them complicates your exemption. You keep the ability to say no right up until you sign. The contract binds when you countersign and accept the funds. Before that, the investor made an offer, and that's all. And a signed agreement plus a wire is not. The investor is in. The investor is in when you sign. So let me flag a few things not to assume. Don't assume this is administrative paperwork. It's the closing document. Don't assume you've lost the right to reject someone. You keep that right until acceptance. And this last one catches sponsors on the accreditation piece, especially with Rule 506e. If you're advertising your deal under 506e, you have to take reasonable steps to verify that every investor is accredited. A checked box inside the subscription agreement is not enough on its own. Under 506b, where you're not advertising, self-certification inside that agreement can generally support your reasonable belief. But under 506e, the box is the claim, and the verification, the tax returns or the third-party letter, is the proof. Don't let one stand in for the other. So here's the field note. The subscription agreement is not just a signed form. It's the offer that lets an investor in, the record of what they promised, and the mechanism that binds them to the operating agreement without a mountain of signatures. It's only as strong as the substance inside it and the process around it. The sponsor who has a signed form and the sponsor who has a defensible one are not the same sponsor. Knowing that difference is the whole game. The longer written version is in the show notes. I'm Tilden Moschetti, and this has been Syndication Attorney Field Notes.